Good afternoon and welcome to the thorough newspaper analysis for 6th September 2022. So today we have one editorial article which has been taken from the Indian Express and is titled September 6th, 2018 and has been authored by Menoka Guruswamy. Now this talks about the approach the Indian judiciary has taken in order to make a more inclusive space in the Indian society for the queer community. Following that, we will have the news update and the legal news, which you know are a part of LawSikho's initiative to keep its readers and students updated with the current affairs that is happening in and around of India. So for the editorial article today, on 6th September 2018, the apex court of the country in the case of Navteej Singh Johar and others versus the Union of India liberated the queer community from the evil clutches of section 377, which basically criminalized homosexuality. So this is not the only case. Since then, the Indian judiciary has been constantly striving to make the LGBTQ plus community and their issues a prime focus in the society and to alleviate them of their sufferings. So based on that, other judicial pronouncements of prominence regarding the LGBTQIA plus community are, firstly, Madhubala versus the state of Uttarakhand. Now this case is important because this was the case which held that live-togethers of same-sex couples was a constitutional right for each of them and a human right also. In the case of Vanitaben Damjibai Solanki versus the state of Gujarat, police protection was given to two women. Now, these women were threatened by their families because they were in a relationship, and upon approaching the court went forward and gave them police protection so that the families could not attack them. In the case of Pramod Kumar Sharma versus the state of UP, which was in 2021, the Allahabad High Court directed the reinstatement of service to a home guard who was homosexual. So the only reason the home guard was removed from service was because he was homosexual. Aggrieved by this, he went forward and moved the Allahabad High Court, and the Allahabad High Court swiftly came to his relief. For the case of S. Shushma versus the Commissioner of Police, the Bombay High Court accepted that even the judges would have to change their assumptions to ensure that justice is given to the individuals of the queer community. Now, the recent judgment in the case of Deepika Singh has once again shown that the Indian judiciary is relentlessly trying to change the perception of families to build a more inclusive space. For the news updates today, we have firstly, President nominates D.Y. Chandrachud as the next chairperson of NALSA. Now, the Supreme Court Judge Justice D.Y. Chandrachud has been nominated by the President of India, Draupadi Murmu, as the next executive chairperson of the National Legal Services Authority, or NALSA. A notification to that effect was published in the official gazette by the Ministry of Law and Justice. Secondly, in a very happy news for us, India overtakes United Kingdom as the world's fifth largest economy. India has overtaken the United Kingdom to become the world's fifth largest economy and is now behind only the US, China, Japan, and Germany, according to IMF projections. Thirdly, Liz Truss to replace Boris as PM. The Liz Truss will replace Boris Johnson as Britain's Prime Minister, traveling to see Queen Elizabeth in Scotland, before appointing a new team of ministers to tackle an economic crisis and draw her deeply divided party together. She also defeated Rishi Sunak to win this position. Fourthly, we have AIFF gets its first player president. Now, Kalyan Chaubey defeated Baichung Bhutia to become the All India Football Federation president in the elections, to be the first player president in the history of AIFF. Fifth, we have Karnataka launches the VentuRISE Global Startup Challenge. The Karnataka government announced the worldwide startup competition VentuRISE Global Startup Challenge, which aims to aid entrepreneurs in the manufacturing and sustainability related industries. The global startups will give business owners from all over the world a stage to present their cutting edge goods or solutions and make connections with potential investors. For legal updates today, we have firstly, SEBI circular on standardization of procedure for debenture trustees has retroactive application, and the same has been held by Supreme Court in the case of Securities and Exchange Board of India versus Rajkumar, Nagpal, and others. So the SC has allowed retroactive application of the SEBI circular on standardization of procedure to be followed by the debenture trustees in case of default by issuers of listed debt securities. Secondly, we have section 125 of CRPC, major son or a daughter not entitled to maintenance except when a statute or personal law comes to aid. Now, the Jammu and Kashmir High Court held that a major son or a major daughter would not be entitled to maintenance unless a statute or personal law aided the same. In such a case, the magistrate cannot give such maintenance in exercise of his power under section 125 of CRPC. The same could be done by a family court under the aforementioned provision, that is section 125 of CRPC, and under section 20, subsection 3 of the Hindu Adoption and Maintenance Act. And the same was held by the High Court in the case of Showkat Aziz Zargar versus Nabeel Showkat and another. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel, the link of which you can find in the description, or you can always scan the QR code that is given on the screen. For any further information, please feel free to visit www.lawsikho.com. Thank you.